At this time, I'd like to call this meeting to order. Good evening, everyone. Today is Thursday, September 8th, 2022, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. I would like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino K'iche' peoples. Commissioner Montemayor, would you like to lead us in the Pledge of Allegiance?
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, everyone. Ms. Secretary, may we have a roll call?
Commissioner Kirpies.
Present.
Commissioner Maggio.
Present.
Commissioner Martz is absent for tonight. Commissioner Montemayor.
Present.
Commissioner Wright.
Present.
Vice Chair Ayers.
Here.
Chair Topshin.
Here, we have a quorum. Approval of agenda is next item. Commissioners, has everyone had a chance to review the items before us tonight?
Motion to approve the budget, the agenda.
I'll second.
We have a motion and a second. Ms. Secretary, may we have a roll call?
Commissioner Kirpies.
Aye.
Commissioner Maggio.
Aye.
Commissioner Montemayor.
Aye.
Commissioner Wright.
Yes.
Vice Chair Ayers.
Yes.
Chair Topshin.
Aye. Motion passes. Thank you. Next is approval of minutes. Before us, we have the minutes for the meeting on August 25th, 2022. Has everyone had a chance to review them?
I'll make a motion to approve the minutes.
We have a second?
I'll second.
Okay. We have a motion and a second to approve the minutes. We're ready for the roll call.
Commissioner Kirpies.
Aye.
Commissioner Maggio.
Aye.
Commissioner Montemayor.
Aye.
Commissioner Wright.
Abstain.
Vice Chair Ayers.
Yes.
Chair Topshin.
Aye. Minutes are approved. Motion carries. Thank you. Public comments is the next item. Ms. Secretary, do we have any speakers tonight?
We don't have any public comment at the time, but we do have speakers for the appeal.
For the appeal. All right. So then, since we don't have any speakers at this time, we're going to have the manager's report. Good evening, Mr. Manager, Mr. Hollop.
Good evening, Chair, Vice Chair, Commissioners, Jonathan Hollop, Stabilization Manager. Try that again. Good evening. So what we have on the look ahead is plenty of appeals coming down the pike, one this evening, 3 more scheduled. Might put a few more items on here related to council directives. Also working on getting a study session scheduled, possibly in November, maybe December, and working on a scope of that. Also, I'd like to report that Betzetic reported 21 new cases for the month of August. I inquired with them about what the majority of those were. They continue to be non-payment of rent cases, although there are a few nuisance and breach of lease cases as well. You might recall last meeting I mentioned that council at its August 15th meeting directed staff to return to council with a recommendation on ending the rent increase freeze and having a cap on the AGA at 3% going forward. In conjunction with that direction, staff was asked to do outreach to tenants and landlords to discuss the ongoing impacts of the COVID-19 pandemic, in addition to how the end of the rent increase freeze and the cap would affect landlords and tenants who are either tenants in rent-stabilized properties or own those properties. So today, the city issued a press release that some of you may have seen, and that goes over the outreach that the division will be doing. It will be having 2 Zoom outreach meetings, one for tenants on Tuesday, September 27th at 7 p.m., one for landlords on September 28th at 7 p.m. We'll also have 2 in-person meetings at Plummer Park, one for tenants on Thursday, September 29th at 7 p.m., and for landlords on Tuesday, October 4th at 7 p.m. In addition, staff will be at the Helen Helen Albert Certified Farmers Market at Plumber Park on the following Mondays, the 12th, the 19th, the 26th, from 9 to 2 p.m. And we will also, we already have a survey that's available online. If anyone needs a paper copy, we can provide that. The survey is easiest to access if you just go to the main website of the city, weho.org. At the landing page is a search bar, and if you type into the search bar rental survey, the very first result that comes up will direct you to the survey, which is in English, Spanish, and Russian. And again, if anyone who is watching or if any commissioner wants to get that as a paper copy, be happy to provide that, and that can be done by emailing the division at rsd@weho.org. And I'm available for any questions.
Thank you. Commissioner Kurpis?
Yeah, I have a question about the outreach efforts. Is it possible for our September 22nd meeting to have a listening session or whatever, have that as items, invite the public to come and speak on that matter? We wouldn't be deciding anything, we would just be listening.
I think that would be possible as a separate item. I mean, normally I think that sort of thing would fall under public comment, but an agendized item to just hear comments, I don't know. I've never done that before, but if it's feasible, I don't see why not.
I'm sorry, Josh, I didn't hear the question.
I was asking if they could add to their outreach strategy on our September 22nd meeting, adding something to our agenda for the public to come and speak on the matter and us just to listen to some of the comments.
Okay, thank you.
It wouldn't be an actionable item, it'd just be another opportunity for the public to participate.
I think it's a good idea.
We can do that.
Okay.
Yeah.
Great. Commissioners, questions? All right. Commissioner Wright?
The 21 new cases, are those evictions when you mentioned Betzetic?
Those are all eviction cases, correct.
Thank you.
You're welcome.
Okay. Can you guys, staff, send us the email maybe with the dates for this forums, for this gathering, so maybe the commissioners would like to attend?
Of course.
Thank you. I guess no other questions. Thank you, Mr. Manager. Commissioner Kurpis.
Based upon that, I do have a question. Would this be one of the, these would not be public hearings, so would we be limited to 3 members maximum at attendance at any of the outreach sessions?
I think that would probably be advisable. I can talk with Mr. Natalizio about that, but I think that would be the case, yes.
Thank you.
Well, so you plan on being there then? You got that meeting, is that correct?
On the 22nd, that would be our meeting. I was referring to his question about the other outreach sessions that we may want to attend.
And I think we can't be there and we can't have a quorum. I think we can only have 2 or 3, right?
3, yeah.
Right.
So when when staff sends the information, we can coordinate to make sure that there's no issues there.
Yes, since there are 4 meetings, we can split commissioners. And plus, I don't believe that everybody wants to go. Yeah, we can coordinate that. Thank you, Mr. Manager.
I just had a question about that. If we don't communicate with each other while we're there, is that still a Brown Act, potentially a Brown Act violation? If we are present but don't actually interact with each other?
The short answer to that is no.
All right. Okay, then. Thank you. We'll wait for further clarification on that. And I'm going to move on to the commission comments. Commissioners, are there any comments at this time? Vice Chair? You said? Commissioner Kurpis and then Vice Chair.
I was just going to mention that today's LASA released the homeless account for LA County for last year, and there showed a 4.1% increase in homelessness, unsheltered population throughout the county. They said this, they mentioned this in an optimistic tone because this is a decrease from the increases they've seen in the past. It was less of an increase that they've seen in the past, and they are hoping, it's a little early to tell, but they're hoping that this has created a plateau, or that they were seeing a plateau in the increase in homelessness. They also did conclude the briefing about some of the reasons why it wasn't so high, they speculate, was because of the increased funds and resources available through COVID relief that kept that number down. My concern, and several other people's concern, is that those programs are ending. If they haven't already, they will be soon. And we will see an effect of those programs going away over the next several months. And so I don't have a good optimistic feeling about next year's count. But they are looking for volunteers to do the count in January, so clear schedules, January 2023.
Josh, I saw that information too, and I think the increase was in LA County, but the decrease was in LA City. I think that's how they divided it.
Percent increase in LA City and 4.1% in the county, but it was much less than what they saw from 2018 to 2020.
Right.
All right, thank you. Vice Chair.
I just wanted to mention that I was really proud of my city this week. Just driving around, happened to be listening to the NPR station, KPCC, and the LAist newsroom did a story on the city of West Hollywood's approach to rent control. And the story was a little broader than that. It was comparing West Hollywood's rent control ordinance, or rent stabilization ordinance, I should say, to other cities around us, and we were the good example. And our rent stabilization manager, Jonathan Holub, was featured in the article as well, and as usual represented our city extremely well. And you know, it just made me feel lucky to, as a renter, be living in this city, and that has a strong platform for renters' rights. Thank you.
Thank you, Vice Chair. Okay, if there are no more comments from the commissioners at this time, you will have more time at the end of the meeting. Now, what's next is the appeal section of the agenda. And we have one appeal before us this evening, and that is a rent decrease application number D-4668 that pertains to the property address 7621 Hampton Avenue, unit number 203. This appeal has to do with the rent reduction due to the loss of housing services. The appeal is filed by the landlord. Let me first confirm if, Ms. Secretary, do we have both parties present, tenant and a landlord?
Yes, we do. And we have one tenant attending via Zoom, and then we have one tenant in person.
Okay.
And also the landlord is present.
All right, great, thank you. Okay, before we begin, I'd like to take a moment and explain the appeal process for the parties. First, the Commission will hear the staff report presented by the legal counsel, Mr. John Natalizio. Then the appellant will, in this case, is the landlord, will speak first. You will have 5 minutes to present your case. You have the option of dividing 5 minutes into 2 segments. You may use part of your 5 minutes for the presentation and a part of 5 minutes for the rebuttal. The respondent will speak second, and the tenant will have one 5-minute segment to present the case on the appeal subject. When it's time for you to speak, please state your name. Come forward to the microphone, state your name, city of residence for the record, and for the appellant, you would have to state, you have to indicate how you would like to divide the time. And then you proceed with your comments. Since your speaking time is limited, it is very important to keep the following things in mind. Make sure you keep your comments on topic. The only information you can share, you can present tonight is the information that was presented at the hearing. New evidence cannot be received or considered by the commission. And if you go off topic, you may be interrupted at any time. With that said, I will open the oral argument portion and invite the landlord to the podium. Oh, I'm sorry. It was premature. So we're ready for your report, Mr. Natalizio.
Thank you, Chair, and good evening to the Chair and Vice Chair and the Commissioners. For everyone else, my name is John Natalizio, and I am the legal counsel to the Rent Stabilization Commission for the City of West Hollywood. As the Chair stated, this appeal was filed by the landlord in response to the hearing examiner's decision granting the tenant, I hope I'm pronouncing her name right, Lily Malek's rent reduction application relating to the elimination of parking and laundry services. Regarding the parking, according to the tenant, she utilized off-street parking at the commencement of her tenancy in July of 2016. She alleges in February of 2018, the property manager granted her on-site parking. And then in either late 2018 or early 2019, the current landlord acquired the property. At some point thereafter, the landlord began construction on the property, which intermittently impeded the tenant's access to on-site parking. The tenants alleged that while landlord informed tenants that the construction was due to earthquake retrofitting, tenant alleges that the construction was due to landlord constructing 2 small accessory dwelling units on the property. According to tenants, in February 2021, the construction made parking in the designated spots completely inaccessible, and ultimately landlord eliminated the tenant spaces for parking. Regarding the on-site laundry, according to the tenants, the property had on-site laundry, which consisted of 1 washer and dryer. However, because of the construction, the laundry room was no longer functional, and the tenants alleged that the landlord informed them that the tenants could use a laundromat, which was located several blocks away. The hearing examiner's decision granted a rent decrease as follows: $80 for the issue relating to parking, $28 for the issue relating to the washer, and $28 for the issue related to the dryer. Therefore, relevant to this appeal, there was a rent decrease of $136 was awarded to the qualifying tenants for these issues. Landlord filed its appeal of the decision, and the appeal claims that the decision is not reasonably supported by the finding made or the evidence in the record. And specifically, landlord argues that it did not receive notice of the underlying hearing date from the city. And outside of the procedural argument, landlord's appeal includes a number of new matters and evidence. In staff's opinion, there is substantial evidence in the record supporting the hearing examiner's decision, and therefore staff recommends that the decision be affirmed. Regarding the allegation of notice, the city mailed notice to of the hearing to the tenant and landlord on April 25th, 2022. The mailing address used by the city for its correspondence with the landlord was the address the city had on file. And at the time of the notice, there was no record in the city's file evidencing any sort of change of address. Additionally, the mailing address used in the notice for the underlying hearing is the same address used in the notice of the hearing examiner's decision. Because the landlord received the decision as evidenced by this appeal, it reasonably follows that landlord therefore received the notice of the underlying hearing, and ultimately there's no evidence in the record that would support landlord's position that the city did not provide sufficient notice. Regarding the issue for on-site parking, tenant alleges that it has been eliminated due to ongoing construction. Since the landlord did not submit any evidence, nor did it attend the hearing, the testimony of the tenant is unrefuted. Therefore, staff believes that there is substantial on the record to support the hearing examiner's decision that the landlord substantially reduced or discontinued parking as a housing service without a corresponding rent decrease. Regarding the laundry, the record is also uncontroverted that the use of the common area laundry room has been eliminated. The property previously had one on-site washer and dryer, and the construction does not justify the elimination of a housing service. Therefore, staff believes that there's also substantial evidence in the record to support the hearing examiner's decision that the landlord substantially reduced or discontinued laundry as a housing service without a corresponding rent decrease. Therefore, staff recommends affirming the hearing examiner's decision and adopting Resolution RSC 22-616. You, as the Commission, have the power to affirm, reverse, modify, or remand the appealed decision of the hearing examiner. The Commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the Commission to make sure there is substantial evidence in the record that reasonably supports the hearing examiner's decision, is credible, and of solid value. If that evidence is found, then the decision must be upheld, even if there is also evidence that could support a different outcome. The Commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence. As it relates to questions of law, the Commission applies an independent or de novo standard of review to the hearing examiner's conclusions of law. Thank you.
Thank you. Ms. Natalizio, questions for the council? Yes.
Yes, thank you. I have since there's a question of the noticing, am I correct that we first need to decide whether that is a legitimate issue, and if the Commission did decide that there was a question about noticing, wouldn't it be better for the tenant and landlord to know that before they gave their 5-minute speaking? Or I think that it might be relevant mostly to the landlord. And how would you suggest that we do that procedurally?
Well, I think in terms of how to handle that, I think if the parties want to use part of their 5 minutes to address notice, for example, if the hearing examiner is whatever the hearing examiner's argument is going to be, that can be used within the 5 minutes. I don't see either party being negatively affected by giving their full arguments and then the Commission ultimately deciding like a remand is necessary or something like that. I think the parties still have their full 5 minutes to present their arguments. So I wouldn't see, I guess, any need for a deviation from the Commission standard procedure.
Okay. It seems like we would either be listening to the landlord stand up here for 5 minutes giving us new evidence that if we don't think that they received the notice would be relevant. That's one that would be relevant. But if we didn't think that they had a valid claim that they didn't receive the notice, then they'd be basically speaking for 5 minutes on evidence that's not in the record. And
I understand what you're saying. I don't think that, in my opinion, they would need to change the way the Commission handles it. I will say that I think if the Commission wants to, create a preliminary bar and a discussion in terms of was there not sufficient notice, as long as the parties have an opportunity to address that before the Commission deliberates, I think that the Commission could decide whether or not they want to deviate from the policy and the procedure that's set forth in the regulations. So I think that is a possible option, but that would be up for the Commission to decide if they wanted to take some sort of deviation.
And then I have a couple questions just about, if you could remind me on the process for how one applies for a hearing, a rent reduction hearing, what requirements they have prior to requesting. If it's a 30-day, I know some things require you have to notify the landlord 30 days, give them 30 days to fix it. If they don't fix it, then you can have a hearing. I don't know if that applies to all things. And then the second part of my question would be, what does the code require of the tenant to notice?
So the overall procedure is the tenant has to submit an application in. I know for matters relating to maintenance, maintenance requires a 30-day opportunity to cure. However, that's not absolute. And you have to give me a second because there is language in the code that sets forth something to the effect of if it's evident that the landlord isn't going to fix the issue, that 30 days isn't required. So just give me 1 second here.
If you're looking for the section regarding notice that the tenant must give, it's Rent Stabilization Reg 60010, Subpart D.
Thank you, Commissioner Wright.
While he's looking that up, I think I have a question that staff can answer about page 83. Is it just my printout, or did everyone get? But my hearing application that I see is blank. It has a signature and it has a parcel identification number, but other than that, it's pretty much blank. And I'm just wondering if that's a printing error or.
What page is this?
Page 83, I believe, in our packet. Oh, yeah, okay, so I have it, okay. That answers part of my question. May I look at yours?
Signature and date?
Yeah, mine's different than, mine doesn't print out the same way. Thank you.
And then Commissioner Kerpes, what the regulation states is that that a tenant applying for a downward rent adjustment has to submit at least 30 days, a declaration or some sort of evidence that at least 30 days has elapsed since the tenant has served the landlord with a written notification of the grounds for the requested rent reduction and a request for remediation of the conditions or services or performance of maintenance. However, if the landlord has refused to perform the work and no remediation of the conditions or services has occurred, then the 30-day period doesn't need to be met.
For example, if the landlord texted back, no, we're not going to do that, or,
Sure.
Yeah,
Right.
okay. Thank you.
I have one question.
Yes, Commissioner, please.
For legal counsel. Would it be advantageous for us to know why one tenant opted out, or is that none of our business?
Yeah, that wouldn't be relevant, Commissioner Maggio.
Thank you.
Other commissioners? Commissioner Wright?
Hello. I have a few questions, mainly for clarity. On page 74, there's a footnote 3. The sentence says, on the landlord's application, both rent decreases were reversed by rent stabilization staff in January 2022. What application is that footnote referring to?
Sorry, what page, Commissioner Wright?
Page 74, footnote 3.
And sorry, Commissioner Wright, so what's the question about the footnote?
It mentions the landlord's application, And I was just wondering what that was referring to.
Oh, it might be a reference to compliance determinations submitted
Gotcha.
by the landlord.
Okay, thank you. And then on page 14, and so the second paragraph that starts with additionally, it describes what it's discussing the mailing of the notice, and it says that there's substantial evidence of record to support that the landlord had received notice. And I was wondering, the substantial evidence standard is generally when we're looking at what the hearing examiner decided. And since the hearing examiner didn't opine on service, is that still the correct standard for us to consider?
Yes, the standard of review would still be substantial evidence.
And then what documents do we have on file that reflect the 9663 address that the notice was mailed to for the landlord?
I'm sorry, could you repeat that?
What documents do we have on file that reflect that address?
Oh, the address used in the notices?
Correct.
So those would be found in when the property owner or the landlord purchased the property. They would have to submit a form notifying the city of a change of ownership.
And do we have that in our packet?
No, not to my knowledge.
All right, thank you. I have no other questions for staff. Thank you.
Thank you, Commissioner. Other commissioners? Just for clarification purposes, Mr. Natalizio, on page 14, what it says, the hearing examiner identified that if a landlord provides an on-site parking spot to a tenant on or after January 1st, 2004, is this that date of the ordinance that states that parking becomes a non-severable part of the rental unit? Why we have that date, January 1st, on or after January 1st, 2004?
Your question is, why was that date chosen?
Yeah, wouldn't that, it wouldn't matter when the parking was provided, correct? Why it's important to use this date, that if the on-site parking was part of the tenancy, provided on or after January 1st, 2004. What if the parking was provided before that date?
So I guess to answer the first part of the question, I'm not sure the legislative history for why January 1st, 2004 was chosen. But presumably if there was on-site parking eliminated prior to this date in the code, then this provision would not apply.
Mr. Chair?
Sure.
January 4th, or January 2004, I believe, is when the city passed the ordinance that it was no longer an option for a landlord to remove
Parking
a
space.
parking space from a unit.
Which was the parking ordinance that we will call, yeah.
Maybe, yeah, I don't know.
Because the reason why I just wanted that to clarify is because under the ordinance, any housing services provided anytime would be a housing service, landlord-provided housing service, and the removal of it would require rent reduction.
Sure, there's other ways parking can become a housing service.
Okay.
Under the RSO, that's correct.
All right. Okay. Thank you. I don't see any further questions from the Commission. Ms. Secretary, I wanted to confirm. So we have the tenant, right, here to speak, and you said there is another person to speak?
Yes, so we have two tenants.
We have two tenants. They want to share the 5 minutes, or it's going to be additional?
Chair, the way it would work is the appellant tenant would be the one provided the 5 minutes, and if there were other tenants that wanted to speak on this, it would be as part of the public comment portion of this item. So before,
Before we start the oral argument, then we have to provide the 3 minutes as a public comment portion.
that's correct, Chair.
All right, thank you. And with that, before we begin the oral argument portion of the appeal section, so I'd like to, as a part of a public comment, invite Ms. Secretary, who's going to speak? What's the name of the person?
For the public comment?
Yeah.
For the public comment will be Mary Jones in person, and then the tenant on Zoom is the appellant tenant.
Okay, so we have two people speaking in a public comment segment. All right. And this is for the legal counsel. Do I need to read the disclosure regarding the public comment part?
I would read it just so that way the speakers are aware of what the parameters are for their comments.
Okay, I'll do that. All right. So before that, I will just read on the record that the Rent Stabilization Commission values your comments. However, pursuant to the Brown Act, the Commission cannot act on items not listed on the posted agenda. Members of the public have 3 minutes to speak. The public comment period is to address the Rent Stabilization Commission on agenda items or items of general interest within the jurisdiction of the Rent Stabilization Commission. An additional public comment period is available at the end of the meeting. So with that said, whoever is the first speaker, public speaker, Ms. Secretary, I'd like to invite that person. Can you repeat the name, please?
Just to clarify, you want the public comment?
Public comment,
Okay.
yeah.
So for the public comment will be Mary Jones here in person.
Okay. Ms. Jones, please come forward to the podium. And before you begin, you will have 3 minutes. And before you begin, please state your name and the city of residence for the record.
Mary Kay Jones, West Hollywood.
You may begin now.
I have lived in 7621 Hampton Avenue, apartment 204 now, since August 18th of 1974. When I moved, I had parking and I had laundry. Now I have neither. I'm 81 years old. I park on the street because the parking is the driveway. I'm too old to play musical chairs or cars with the other tenants. I'm afraid to go out at night. I don't want to drive at night because I may come home and I will not have a parking spot on the street. And I may have to park 2 or 3 blocks away and walk. And it's, as you all know, it's not as safe as it used to be, especially for an old lady like me. But I would just like for John to explain how the parking is going to work. The laundry, I take it to the laundromat. I do fluff and fold because I'm too old to sit in the laundromat for 2 or 3 hours to do my laundry, which costs me a little bit more than I would like to pay. And that's all I have to say. Thank you.
Thank you. Thank you. Next speaker. You said it's on Zoom, right?
Yes.
Okay.
Hello, my name is Lily Malik.
Wait, just 1 second. 1 second. Is this a tenant?
Yes, this is a tenant.
Okay, so if this is a tenant, the tenant has to wait for the oral argument part. I thought that's a public speaker, not part of the appeal.
No
Okay.
problem.
Okay. All right. So with that, I'll close the public comment part, and I will begin oral argument with the landlord's presentation. So I'd like to invite the property owner, the landlord, to the podium. And sir, before you begin, please indicate how would you like to divide your time. You have 5 minutes, and you can use part of the 5 minutes for your presentation and part of your 5 minutes for the rebuttal, if you want to split.
2.5 and 2.5.
Can you speak up, please?
2.5, 2.5.
2.5, 2.5. Okay. So, Ms. Secretary, please note that. And before you begin, please state your name and the city of residence, and you will have
John
2.5
Fred.
minutes to speak.
I'm sorry, go ahead.
Go ahead. You may begin.
Good evening. John Fred and Beverly Hills. And unfortunately, I did not get a notice, to be appear in the last meeting that you guys had. And some of the stuff that, being told here is not accurate. The parking, we only had for 2 tenants that, they're both here.
Mr. Fred, can you speak directly to the microphone, please?
Yes, we had 2 tenants that they had parking in the building, but Miss Lily Malik never had a parking. I do have copy of the previous manager that I believe you guys should have copy of it, that indicate that, she never had a parking there, never was assigned to any parking or had any parking there. And the laundry, it's temporary, is out of order. We're going to put a new laundry there. We are doing retrofit to demand of the city of West Hollywood, and we are adding ADU as well. But we only 2 people, they had parking.
That concludes your comment?
Yes.
Okay, you have some time reserved. How much time?
And some of the tenants, they already have, 3 tenants, they already have laundry inside of their unit.
Okay.
1 minute left.
1 minute left, and plus 2.5. There will be 3.5 minutes for your rebuttal. Sir, yeah, if that concludes your presentation part of your testimony. So let's see if the commissioners have any questions. Commissioner Kerpes?
Yes, you mentioned, Mr. Fred, that you did not receive the notice. What evidence can you provide us that why we should believe that you didn't receive the notice? I know that's a difficult question to answer, but
it is a tough question to answer. What kind of.
Do you have other difficulties with your mail? Have you ever made a complaint about the mail service? Do you have evidence of receiving late payments or late bills from the mail service?
We do get late payments sometimes, but.
But did you bring any of that this evening to provide to us? That's the question that you want us to answer, right? Is whether we believe that you received the notice or not?
I did not receive the notice, sir.
I understand that that's what you're saying, but did you bring any
evidence?
evidence?
Do I have any proof? No, I cannot prove it.
Okay.
If I didn't receive it, how can I prove I did not receive it?
Through those other examples, I'm just curious if you had any other examples, but it doesn't sound like you do. Thank you.
Sure.
Vice Chair?
It seems, my understanding is that the ownership or the business management of the building changed hands.
Correct.
And when your company took over, did you file papers with the city to let the city know that you were the new owner or management company for the building?
When we purchased the building, we used the same manager up to almost about 10 months ago, a year ago. So we had the same management from the previous owners.
Okay.
What he did, I have no idea.
Okay. So, okay.
But
that's it.
I did take over the management about 1 year ago, 10 months, 1 year ago, something like that.
All right. So it is possible that the city, when this hearing took place, they gave notice to a management company and they didn't get it to you, or there was.
That's possible.
Okay, I see. Okay, thank you.
Okay, thank you. Commissioner Maggio.
In regard to your retrofitting, is there subterranean, is there garages under apartments? Is that
Subterranean, no, but there is. There was parking underneath Mrs. Jones' apartment, correct?
So some places, so that's why you need retrofitting, to make those places
City
safe.
demanded to be retrofitted, yes,
That
sir.
I know. Thank you very much.
Thank you. Commissioner Wright?
What's your title and role? What's your title and role?
Manager.
Manager. And what is your mailing address?
622 North Rodeo Drive.
And when did that become your mailing address?
Recently.
Can you give me a time frame?
We had another 9663 Santa Monica Boulevard was the previous address that we have both addresses.
And with the 9663 Santa Monica Boulevard address, is there a suite number?
Suite number 1026.
One more time?
1026. And it's still that's available. Both of them are available for us.
And do you know why you received the notice of the appeal but not the notice of the hearing?
I have no idea.
Who received the notice of the appeal?
I did.
You personally received it?
In the mailbox, correct.
Do you know whose address is 489 South Robertson, Suite 207?
That's that was the manager before.
And had you received notice of the hearing that took place on May 9th, would you have attended?
Yes.
How frequently are you personally at the property?
Recently, I'm there maybe about 2 times a week.
And around the week of May 10th through May 6th of this year, do you recall if you were at the property at all?
May 10th.
Sorry, May 2nd through May 6th of this year. Do you recall if you were at the property at all?
May 2nd. I could have. I don't recall.
Okay. No further questions. Thank you.
Thank you. Commissioner Montemayor, please.
Commissioner Wright handled the questions I was thinking of. Thank you.
Okay. All right then. I think I don't have any questions at this time. Sir, you may have a seat, and you have 3.5 minutes reserved for your rebuttal. Okay?
So, do you want me to sit?
Yeah, you may have a seat. I'll invite you back to the microphone. At this time, I'd like to provide the 10 opportunity to use the 5 minutes, and you may introduce yourself, state your name and the city of residence, and you have 5 minutes.
Hello, my name is Lily Malik. I have been a tenant since July of 2016, I believe, if I'm remembering correctly. I as well had parking ever since I moved in, and laundry as well. Parking wasn't formalized in a document until February 26th of 2018, of which I do have a document from the previous property manager, Mike Froelich. I did submit that to the court, and it was parking spot number 3. And in terms of the washer and dryer, there's really nothing more I need to say other than I did have laundry and it was taken away. What John told myself and all the tenants was that the retrofitting was for earthquakes only and was temporary, and failed to tell us that there was 2 ADUs being built. I actually had to call the city myself to find this out, and so it was under my impression that he had no intention to tell us at all and to just keep us waiting. And I don't believe I have anything further to say other than what Mary already accredited. I'm a single woman. I live alone. I also don't necessarily feel safe parking on the street at night anymore or coming home late. So it's a huge, huge hindrance as a single woman living alone right now. And the washer and dryer, I have to use the one at the laundromat, which takes a couple hours of my day every week. I also have an autoimmune disease, which makes it so it's just not entirely safe for me to be doing that either. And that is all I have to say. Thank you.
Okay, thank you. Ms. Malik,
maybe
we
she
have, don't go away, we have some questions here for you. Commissioner Maggio,
Yes, and who am I speaking to?
are you speaking to the tenant, Ms. Malik?
Malik. Miss Malik, I have some photographs in front of me that show cars lined up in tandem form. Is that the way the cars have been parking, or is that usual?
No, so that used to be the driveway. And at times when there's absolutely no parking, only myself and Greg's son Peter, who live in apartment 201, I believe, will sometimes utilize that driveway. Mary never utilizes it ever. And at times we only use it for loading, because if we have groceries or anything, or large cases of water, we use it specifically for loading, and then we move our cars to the street.
But in general, these cars can't be parked there all the time because you can't get them to the parking spaces because the driveway's blocked.
Correct. Exactly, correct. So that's why we really only use it as a loading zone most of the time, and in emergency situations, if there's really no parking, then we will utilize that. But it's not a forever deal, because it's one car is always going to be blocking the other, and of course we're not in the same household, so there's no great way to really play this Tetris game. So it's really only used for loading purposes.
So there's more cars than there are parking spaces. I guess that's what you would say.
Correct, yeah. There's no parking spaces. It's just a driveway.
Thank you.
Thank you.
You're welcome.
Vice Chair?
I just, not for the tenant, but I have a question regarding, I just want clarification on what evidence we should consider and what shouldn't. My understanding is that we can only consider evidence originally presented, and I understand that there were some additional pieces of evidence that we should not be considering. Can you clarify on that?
Yes, you're correct, Commissioner Ayers. So the regulations provide that only evidence considered at the hearing and submitted to the hearing examiner can be considered, and any evidence that is, or matters brought up that were not submitted to the hearing examiner cannot be considered. The only exception would be, and give me 1 second, I'll get the exact language for you. So no new matter or evidence shall be received or considered unless it is shown why such matter or evidence could not, with due diligence, have been produced at the hearing before the hearing officer. So if the commission wished to consider the new evidence, it would have to deliberate and make that finding.
Thank you.
Thank you. Commissioners, Commissioner Wright?
Good evening. I had an opportunity to listen to the hearing, and at the hearing, I recall you saying that you didn't have parking the entire term of your tenancy, that at some point you obtained parking. Can you, and just now you stated that you've had it your entire tenancy, so can you clarify when you were granted parking?
Yeah, so I am unsure as to why it was said in that manner, yet I did have a parking spot the entire duration of my tenancy. The other tenants can affirm that. I just wasn't granted an actual parking spot until February 28th of 2018, yet I was consistently since July of 2016 parking in a parking spot in the back.
And did you have full use and access to it prior to the date that you were given a designated parking spot?
Yes.
And just to clarify, did you ever share it with anyone, or was it strictly yours, just sort of not in an official manner?
Exactly. Strictly mine, just not in an official manner.
Okay, and you submitted a text message, I believe it's marked as Exhibit 1, and it looks like it's a message between you and John. Can you tell me what date that message was sent? The copy we have is just so small that I'm unable to tell what date that was.
Yeah, let me see if I can find Exhibit 1. What page is that? On the packet.
One moment.
Sure.
Page 85.
Okay, page 85. Let me go down there. You know what? It's showing up super small in the packet also, but okay, let me see. Okay, great. Let me just look into my text messages right now. I can find that for you. 1 second.
Thank you.
Yeah. Okay, that was March 14th of this year.
Perfect. Thank you so much. And
You're
just,
welcome.
I think just a couple more. Did you post notice of the hearing on the property?
Is that directed at me?
Yes, ma'am.
A notice of the hearing for the previous one that I filed?
Yes, ma'am.
No, I wasn't under the impression I had to post it on the building.
No further questions. Thank you so much.
Okay, thank you.
You're welcome.
Other commissioners? Commissioner Kerr, please.
Yeah, I just want to ask the question, how did you notice the landlord? I'm sorry if you already answered this. That's for the tenant. How did, or does the city handle the noticing?
The city handles the issuance of the notice of the hearing.
Okay.
But I'm assuming this is what Commissioner Wright is alluding to, is that in the instructions for the noticing, it references a regulation that requires the applicant to post the notice of the hearing in a conspicuous location.
And is that?
So in this situation, the applicant would have been the tenant.
Okay, and is that a correct application of, or understanding of it, that the tenant would have had to post that on location?
Yes.
Okay. Thank you.
All right. I just have one question, Ms. Malik. You mentioned that you agreed that the rental agreement doesn't include assigned parking, but you mentioned that you always parked there since day one?
Correct.
And you said it's parking number 3?
Correct.
Was there any evidence to that? Did you provide anything that would show?
Yes, I did just, well, when I heard about this appeal, I did submit the actual letter.
No, what I mean is to the hearing, when you went to the hearing.
No, it was actually when we were speaking with the examiner, he mentioned it wasn't necessarily relevant.
Yeah, I was just wanted to clarify, if you had anything that would support the statement. You answered, thank you.
Sure.
All right.
welcome.
I don't see any, you have more questions?
Yes,
Okay, Commissioner.
Yeah, just clarification on your last question. Did you say you provided like proof or evidence at some point to the city regarding you having the ability or permission to use parking spot 3?
Yes, that was as soon as I heard that John appealed, and then we had an appeal date. I thought I read in the appeal instructions that you're able to submit within 5 days of the appeal, which is when I submitted the document.
And thank you. Do you know what number that is in the packet? I don't know if I saw it.
I can see if it's included in there.
I don't think it would be included because the new evidence was not provided at the hearing, right?
Yeah.
Am I correct, Mr. Natalizio?
Yeah, any sort of oral argument or written evidence to the commission for purposes of the hearing wouldn't be included in the appeal packet. If anything like that, if like a written statement was provided, that would be provided to the commission through a separate email from staff.
Correct. Okay, so thank you for clarifying.
Only thing is, sorry to note, I do see at least evidence that John submitted after the fact. Yet I don't know if his evidence is allowed. Oh, actually, I do.
No, we're not. We're not reviewing. We're not considering any new evidence, whether from the landlord or you as a tenant.
I do have
Okay.
a question about.
It is on page 41, though. I found it.
Thank you.
You're welcome.
Commissioner Kurpis.
You know, that was my question. That, you know, I don't quite understand the response we just received. That if the person appealing is going to write a statement for why they're appealing, we wouldn't allow the tenant in the case to respond to that in writing as well?
No, sir, I was just commenting on what would be included in the appeal packet. If there was a written submission submitted timely, that would be forwarded to the commission by staff, but it wouldn't be included in the appeal packet.
Okay. But we didn't.
And it's not page 41. Sorry, I reread that. It's not page 41.
Yeah, it doesn't
The
sound like.
opposite. So I guess my question then for staff is, did we receive anything from the tenant since the filing of the appeal?
Yes, and it was forwarded to the commission. I can give you the date in just 1 second. It was forwarded to the commission on September 6th at 6:05.
Thank you. I think this is it.
Along with the additional documents from the landlord, is it correct?
They were documents from the tenant.
Oh, from the tenant.
Yes.
Okay. Yeah, so as I said, I don't believe we are going to receive, accept, or review any new evidence at this time. And I see that.
I just have a question, Chair. So don't we have to discuss that, whether we're going to review the new evidence after the hearing period?
Well, I would defer to the legal counsel to advise on that.
Yes, it would be something that if the commission wanted to consider the new evidence submitted by either party, it would have to make the finding for that specific submission that it could not have in due diligence been presented to the hearing examiner.
And so how do we establish that if it was not, the parties were not able to present to the hearing?
Sorry, could you
That
repeat
would
that?
be, well, I guess at this time, if we're accepting the information from the tenant, so we need to, out of fairness, accept information from the landlord as well. Yeah, No, before we do it.
Well,
So-
there's a difference between, for example, the tenant and the landlord presenting their oral arguments and including facts or arguments. That's one thing. It's a different thing, the commission actually taking that into consideration in their decision. So for example, the entire appeal is presented to the commission, including all of the evidence attached to it. And just because it's in the appeal packet does not mean that the commission is going to consider that new evidence or testimony. So just because it's presented doesn't mean that the commission is going to consider it in its deliberations, if that makes sense.
Okay. All right. So I would, at this time, I'd like to, if no further questions from the commissioners to the tenant. Thank you, Mr. Natalizio. So what I want to do is I want to allow the landlord to come forward and take the remaining 3.5 minutes for your rebuttal, sir, and just, you have this additional time to address based on what you heard. You have 3.5 minutes.
I did provide you guys with the evidence from the previous landlord that indicate that, they never assigned her to any parking in that property. And as you guys can see in the lease, she has no right to park in the property. But even though she parks not only one car, she parks 2 cars, and her roommate's or friend's car in the same property, as you have the pictures. The laundry, she never provided us any evidence that she has a right to park in the property. The laundry, it will be out temporarily. It's going to coming back. I did provide you guys with a plan. I don't know if you guys have it or not over there. And I indicated, where the laundry is going to be, and it's going to come back as soon as the construction is finished. As I mentioned before, there are 2 tenants that they had a right to park there, and they're both here. And other than that, nobody else had a parking to park over there.
That concludes your presentation, your testimony?
Yes, sir.
Okay, thank you. With that, commissioners, any additional questions? Commissioner Marjorie.
Before we go into our deliberation, I would like to address the issue of this new evidence, which was not allowed, and also the fact that information was not received in the mail. In the appeal here, it says that the landlord includes alleged facts and arguments, as well as over 40 pages of documentation, evidence, which was not submitted to the hearing examiner. And the landlord did not submit any evidence to the hearing examiner, nor did the landlord attend the hearing. Therefore, staff is saying that these matters and evidence do not meet our expectations set forth in Regulation 632, which spells out that evidence has to be there for the hearing. But if evidence, if there was not the proper notification, and there is more evidence that should be here before us, I think we have to consider that, and the only way you consider that is to remand this case so that that new evidence could be submitted.
Okay, that's an idea. That's your just. This is not the discussion yet, right, Commissioner Marshall? Because I haven't.
Discussion.
I haven't started the discussion yet. So
I clarified that by saying before deliberation.
Before deliberation. Okay, so let me see if we have questions for the landlord, and we'll get back to that, Commissioner.
No, I don't have any questions.
You don't have any questions?
I think we're done with
All right, no questions, Commissioner Wright?
I do. So at some point, the apartments were renumbered from 1 through 7 through 101, 10. Can you tell me which apartments from the original registration, which has them numbered 1 through 7, now correspond to the new numbering system?
Sure. Apartment number 1 became 101, apartment number 2 became 102, apartment number 3 became 103, apartment number 4 became 201, it's a second floor, apartment number 5 became 202, apartment number 6 became 203, apartment number 7 became 204.
Thank you. No further questions.
Okay, no further questions. Thank you, sir. You may have a seat. And with that, we're going to close the oral argument
Can
portion.
I just say one more thing?
No, you had your time, sir. So it's too late now. Thank you. So what we're going to do is, since the oral argument is closed, let me see if the commissioners have any additional questions for the legal counsel. If yes, Commissioner Kerpis.
So again, can you tell us what the requirement is of the tenant to notify the landlord, including any responsibilities they have, like placing it on the wall or anything like that? I'm a little confused about why this got to us at this point, based on what I've heard.
Right. So as I previously stated, that prior to filing the application, the tenant has to notify the landlord of the loss of the housing service or the lack of completion of a maintenance request, unless that exception I noted earlier is met. And then there is the posting requirement, but that's of the applicant. So there could be a scenario where if the landlord, for example, in an increased case, or a MAR determination, they would also have to post it. So it's just a general requirement that the applicant has to post the, I'm trying to avoid P's now, that the applicant would have to post the notice of the hearing in a conspicuous location. And other than that, I'm not aware of any other specific requirements imposed on an applicant.
So if we learn this evening, I mean, I understand we don't have we don't have that original letter stating, but I understand that in the application, they're basically attesting to the fact that they have done that. So I can understand that we would accept that. But I don't know how we proceed if the tenant this evening said, I did not post a notice at the property, and the landlord is claiming that they never received notice. How shouldn't we remand for a new hearing?
So I guess there's two parts to that. One is, from what it sounds like, is that information either the hearing examiner did not inquire about or was not disclosed at the hearing because there's no mention of it in the record about this issue of posting in a conspicuous location. So if the commission finds that I guess there has been a violation of the regulations or there's been a due process issue, that's a matter for the commission to decide about whether or not a remand is necessary. I guess I don't have an opinion one way or the other for purposes of legal. This is more of a decision by the commission about whether or not they feel like the noticing requirements have been satisfied, or if there's been, for example, a de minimis noticing issue, maybe it didn't affect the landlord. But if the commission does find that there's been a due process issue, then certainly a remand is an option.
So then we could do that, or are you saying that even if we found that there was a due process issue or a posting procedural problem in the beginning, but clearly the landlord has now provided 40 pages of evidence that is available for us to review and contemplate and decide or factor into the decision, in addition to the hearing examiner's findings, are you saying that we would, as the commission, still have the authority to make a decision on those two issues as well, the two issues at hand, the removal of the parking and the removal of the laundry, while still finding that he should have been noticed beforehand?
Sure. I think that if the commission wanted to make the finding that the new evidence was going to be considered because the landlord, because of a due process issue, the landlord did not have an opportunity to submit evidence to the hearing examiner because they didn't have notice, then I think then the commission certainly could consider the new evidence. But I think what you said earlier comes into play, which is if there's, 40 pages of new evidence, a lot of them are substantive documents and pictures. You then get into the issue of, does this kind of turn into a de novo hearing, which is a completely separate matter in the regulations? And at that point, do all parties now actually have to just on the spot address these documents? And so I think from a practical standpoint, or if the commission did want to make the finding that there was a deficiency in the notice, then probably a remand would be the best option.
Okay. All right. Any questions for the council? Oh. Okay. With that, I would just
Why don't we
open
discuss
the
why don't we
commissioner's
discuss if
comments.
we
I
wanna
want
do
to
remand?
discuss that, but I have a couple of comments to make, but I believe the commissioners to start first. Who wants to begin? Commissioner Maggio, you want to start?
I still stand at what I said initially. Whether we think this is moving in one direction or not, if we're missing the information that we need to make it more fair and equitable, then we need to remand this so that the landlord can present these 40 pages. And unfortunately, there'll be a delay, but I think it's the fair way to go. It's tainted, I think, if we do not allow this new evidence to be submitted. Whether it will be substantial or not, I don't know, but I think we should have the opportunity to let it in. So I'm going to support a remand.
Thank you. Commissioner Wright?
I agree with Commissioner Maggio, and I'll lay out the reasoning just so the hearing examiner sort of understands, and so the parties are sort of well aware. So next time around, should we decide to remand, you'll sort of understand why. And so to start off with, we already covered this point, but according to the regulations, section 60010, it talks about the notice that the applicant must give and also the notice that the city gives. And so the section A says that the city shall mail notice of the hearing to the applicant 10 business days prior. And on testimony from the appellant, he verified that his address was 9663 Santa Monica Boulevard, Suite 1026 in Beverly Hills. According to the notice of the hearing on page 79, the address is 9666 Santa Monica Boulevard, but there isn't a suite stated. And the same is true with the notice of the appeal. And so I think we can remain baffled as to why one made it and why didn't, but I don't believe that the address that the landlord stated, he receives mail at, I don't believe that we have enough evidence that it was sent to that address. And I asked if it was in the record, the address that the city had on file, and we don't have that in our packet, so we can't consider that. However, in the hearing examiner's decision, there is a discussion that there were 2 prior cases filed by the tenant. Those case numbers are case number D4570 and case number D4601. And so earlier I emailed Jonathan Hollub and asked what address did those notices go to. and he verified that it was 9663 Santa Monica Boulevard, Suite 1026. And so with that suite number missing, I don't know that we can affirmatively say, or that there's substantial evidence that landlord received notice. Additionally, the section that I referred to earlier, 60010 in the rent stabilization regs, it does say that the tenant or the applicant must give notice 5 business days, posted in a conspicuous location, and tenant did testify that she was unaware of that requirement, and thus we can draw from that that wasn't done. So without having substantial evidence of record that the landlord actually received notice, and based on the landlord's testimony today that had he had notice of the hearing, he would have appeared, I do believe the right decision is for us to remand the case and let the hearing examiner review the evidence of record and allow the parties a fair chance to make their case. And again, since we aren't the adjudicators of facts, it makes sense to me to also send this back to the hearing examiner to adjudicate based on the evidence of record and the testimony, and then for it to come back to us should that be, what happens if there's an appeal.
All right, thank you. Commissioner Montemayor?
It's nice to have a lawyer on the commission. I agree with Commissioner Maggio and Commissioner Wright, and I think there's reason enough to believe, or to at least question, whether the notice was received. And under the tenant's testimony, that part of the regulation wasn't complied with. So for me, that's enough to remand the decision back to a hearing examiner.
Thank you. Commissioner Corpus?
Yeah, I would agree with everything that's said, and I came into this thinking it was very odd, based upon what I had read, that the landlord had not attended and was also making the claim that he didn't receive it. But then when I asked him this evening, he couldn't really offer, there wasn't really any attempts to really prove that. So I appreciate my fellow commissioners pointing that out, the details of both the notification and the detail of the suite, because I think that all, to me, in my mind, it completes the story, and it makes much more sense now as to what occurred. And I would agree with my fellow commissioners on remanding it to the hearing examiner. And Commissioner Wright, you mentioned that you wanted to say this for the record so that both the hearing examiner would be aware of the decision as well. Would you suggest that in future hearings, the hearing examiner maybe start out much like a planning commission or a city council, city clerk does, and says before they discuss anything, the mayor usually asks, how was this noticed? And they say this was noticed by law, blah, 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 blah. And maybe that be part of the formal hearing process of the hearing examiner starting that out to question that, to get that on a record?
Yeah, I think that would be helpful for us moving forward to sort of be able to check that off so we can get into the substance of the appeals before us.
I would agree with that if we could send some sort of message to the hearing examiner of that.
Thank you. Vice Chair?
I agree with what my commissioners, fellow commissioners have said so far. I do believe that the landlord in this case should have the opportunity to fully present evidence that will be considered. And I also believe that the tenant had some critical evidence that at this time we can't consider it, but should be considered at least by the hearing examiner. So for those reasons and others presented, I agree.
Right, thank you. Initially, I thought I'm going to support the affirming the decision because I did not want to speculate on the issue whether the landlord received or didn't receive and why the landlord didn't receive the notices, as long as there was nothing solid or concrete was given. by the landlord to show that the due process was not followed. But my fellow Commissioner Wright, thank you for details regarding the address and the unit number especially. I think that is important, and we may conclude that the notice did not reach the party, the landlord. So therefore, I think out of fairness to the process and to both parties involved, it would be right to remand this case back to the examiner. So anyone would like to make a motion? Maybe Commissioner Wright? Wait, let's hear from the council.
So if the commission wants to go forward with a remand hearing that's within their powers, I would just request before a formal motion is made, if there can be deliberation about the remand orders. For example, does the commission want a full redo of the hearing? Does the commission want the hearing examiner to just consider the evidence submitted to the commission for appeal? Is there specific issues that the commission wants the hearing examiner to focus on? Those kind of things will be helpful to make sure that the hearing examiner understands exactly what they need to do.
Okay, sure. Commissioner Montemayor?
Under the premise that the property manager did not get the notice and wasn't able to attend the hearing, I think a whole new hearing is probably the best approach at this time.
I would agree. I think that if we were to limit it at this point, it may disadvantage the tenant, actually, because maybe there was more evidence that she would like to present as well, or more sufficient evidence, although. So I think I agree.
Okay. Other commissioners? Commissioner Wright.
So I agree with that for the fairness of the process, but I do want to acknowledge the tenants that appeared at the hearing and took time out of their day to appear, who took their time out of their day to appear this evening. So we do recognize that, and we appreciate you participating in the process. But for me, for the fairness of it, I'll ask that you all go through that process again, should that be what we decide, and let it run its course with the hearing examiner again.
So what are we going to do now? Vote on the...
So we would make a motion to remand.
Yes, Council.
Sorry. So there's another step here. So, the resolution that was prepared was to affirm the hearing examiner's decision. So there's two things that could happen. Either we could take a recess for 15 minutes, and then I can redraft the resolution, so this can be resolved tonight, and then I can read the changes into the record, or the commission can make a motion to remand the hearing with instruction to staff to return next meeting with a resolution that the commission would then adopt. So we could either do it tonight or at the next meeting.
What is going to be wouldn't that cause a delay for the tenants and the landlord as well to resolve this if we delayed it to our next meeting?
Yes.
So I'd prefer we do it tonight.
Yeah, so I think we can take a 15-minute, as you said, 15 minutes recess, and...
If you give me to 8:45, then I'll be able to get this drafted.
Sure. We'll be back at 8:45. Take your time, Ms. Nataliza. Thank you. All right, it's 8:45, and we're back to order. I see that the legal counsel is still working, or you're ready? All right, perfect, Mr. Natalizio.
Okay, thank you, everybody. My fingers hurt a little bit. That was very fast typing. Okay, so for purposes of the record, here are the changes that are being proposed to be made to Resolution 22-616. It'll be changing the title from a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming the hearing examiner's decision as to application number D-4668. It'll be changing that to remanding. And then the only other changes will be to Section 4 of the resolution. And Section 4 is going to be repealed and replaced in its entirety. And here is my proposed language for Section 4. The Commission finds that the decision must be remanded. Subsection 1 says that the Commission finds that a remand is necessary for the following reasons. Subsection A, landlord was not provided with sufficient notice of the hearing in violation of the regulations. Subsection B, tenant failed to post notice in compliance with Regulation 60010D. Subsection C, there were questions about whether the city mailed notice to the right mailing address of landlord and/or their representative. Subsection D, there was necessary information and documentation missing from the record that prevented the Commission from determining whether there is substantial evidence in the record to support or reverse the decision, and the decision needed further information, analysis, and clarification. Then subsection 2 will read, the Commission orders a remand as follows. Subsection A, the hearing examiner shall conduct a new hearing and permit the parties to submit any and all evidence relevant to tenant's application. Subsection B will say the hearing examiner shall obtain all information and documentation necessary to determine whether sufficient notice was provided by the city and tenant. And then subsection C will say the hearing examiner shall issue a new decision based upon the testimony and evidence submitted during the remand hearing. Then the rest of the resolution will remain the same.
The resolution have a number now?
It'll still be Resolution 22-616.
In this, I believe it's section 1 of, or no, it was, I think, where it's first, I think you used the reference that tenant failed to do that. Could we just, because it sounds so negative, could we change it to a tenant was stated she was unaware she needed to, or some other statement that shows that it didn't get posted, but I feel like failed, this sounds like we're blaming somebody.
Okay, should I just say instead of tenant failed to post, tenant did not post? Is that softer?
That's softer, sure.
We're very picky here.
So section 1B section 4, subsection 1B will now read, tenant did not post notice in compliance with Regulation 60010D.
Okay, sounds good.
I'm ready to make a motion on that to adopt Resolution 22-616.
Second.
All right, so we have a motion and a second. Further discussion on motion? I see none, and Ms. Secretary, we are ready for a roll call vote.
Commissioner Kerpes,
Aye.
Commissioner Maggio,
Aye.
Commissioner Montemayor,
Aye.
Commissioner Wright,
Yes.
Vice Chair Ayers,
Aye.
Chair Topshin.
Aye. Motion carries. Thank you, everyone. Thank you, commissioners, staff, the legal counsel, and of course the parties. Now, if you have any questions, you obviously can approach our staff after the meeting, or you can contact the department during the regular business hour and clarify your questions. The department's phone number is 323-848-6450 if you have any questions. With that, this concludes the appeals appeal item before us, and we're going to continue with the agenda.
Chair, I just wanted to
Did I
jump.
miss something?
I just wanted to ask if staff or staff, because I don't think any of us know, if staff could sort of just maybe briefly explain to them, to the parties, sort of what the next steps are and what, if anything, they need to do.
They don't need to do anything. Once the resolution is executed by the chair and the secretary, that'll formalize the commission's action tonight, and then staff will go ahead and notice another hearing. It shouldn't take too long to get that on the calendar.
Okay.
You're welcome.
All right. Yeah. So the parties can always contact the department and ask the questions and inquire the information they need to. With that, moving on to the next item, which is the new business. We don't have anything under that item. So items from staff. Ms. Manager.
No further items from staff. Thank you.
All right. Public comments. Do we have any speakers?
No public comments at this time.
No speakers. Moving on to the commissioners' comments. Commissioner Maggio.
Yes, we are a very small city, but we have a gigantic heart and a lot of love. And so therefore, I would like the commission to adjourn our meeting this evening for Her Majesty, Queen Elizabeth II of the United Kingdom.
Thank you, Commissioner. The Commissioner Kerpis.
I just wanted to echo the comments of at least one of my fellow commissioners. I think it was the vice chair, thanking the applicant or the appellant and the tenants and landlords, or landlord and tenants, for coming this evening and participating. And I hope you'll participate in the hearing when it occurs. I know it takes a lot of time and effort, but we really appreciate a fair and balanced process, and hope that it works out for the two parties.
Thank you. Other commissioners? All right. I don't have any comments also. With that, this meeting is adjourned until in the memory of the Queen Elizabeth II, and we adjourn this meeting until the next regular meeting of the Rent Stabilization Commission, to be held on September 22nd, 2022 at 7 p.m. here in West Hollywood Park Public Meeting Room, Council Chambers. Thank you, everyone, and good night.